It's so easy for the license board to disqualify you, to penalize you, and in any dispute with the client, if you did not use a legal contract, you will lose in court. Your contracts have to include certain items like a lien warning and the progress of payments and other legal language that is required. And if it's not there, your contract is invalid and you cannot collect on it, and you certainly will be it will certainly be a violation of the Contractor License State Board code. When there is a change order or a change to the scope of work, it is really important that you document it. You specify what you will do, at what cost, and how long it will take, and what will be the progress payments on the change order itself. And then you want to summarize the original amount of the contract, the amount of the change order, and the new total amount of the contract, and have the customer sign that change order so it's incorporated within your contract. When you sign a contract with a homeowner, the maximum amount you can collect as a deposit or down payment is $1,000, or 10% of the total, whichever is lower. So if your contract is for $5,000, you can only charge $500 as a deposit. If your contract is $20,000, you can charge no more than $1,000. Violating this requirement is a simple catch for the license board. Many contractors get penalties and have problems with the license board because of this simple oversight. As part of the legal requirements, you must place your license number on any printed material like flyers, business cards, car signs, and most importantly on your contract and on your change orders. Well, if you hire an unlicensed contractor, you're in fact hiring an employee. The law defines a contractor as a licensed contractor. Anyone who's unlicensed is an employee, and you are obligated to withhold taxes, pay unemployment taxes, and keep their workers' compensation, insurance up to date. So that's the bottom line. If they're licensed, they're a contractor. If they're unlicensed, they're employees. You can have salespeople. You can have other people go and represent you and sign contracts with homeowners under one condition. They must be registered under your license. They have to be named in the license, and you have to submit an application, and once they're approved, they get a little card that says that they are a salesperson, and then it's legal for them to sign contracts, represent you, give estimates, and talk on your behalf to homeowners. It's important to keep your corporation in good standing. It's important that you file your annual filings with the Secretary of State. It's important that you keep your taxes filed, your corporate taxes. And once you hold on your annual meeting and record it, just to keep your corporation valid, so in case you find yourself in court, you can still be protected under your corporation. It's also very important that you pull permits when required. It's another way for the license board to penalize you and find you guilty of violating the rules and breaking the law. It's really simple, really easy, and there's no argument against it. So you're in a very weak position when you don't pull permits for jobs that require it. Before you do work in any city, make sure you have a business license in that city, and that also includes just giving a proposal, an estimate. You need to have a license, a business license, to do that, to avoid any problems. In any dispute you might have with a homeowner, any mediation with the license board, they will look at the type of work you did, the quality of work you did, and that's why it's very important that you follow the building codes and the standard practices in the construction industry, because another contractor will be sent to check your work. And if you follow the building codes and you follow the standard practices, then you will have a stronger standing in any dispute with homeowner. When you are licensed with an RMO, that means that there's a condition in your license. The condition is that your license is valid as long as your RMO is included in your license and is exercising reasonable supervision. There's no real definition of what is reasonable supervision, but over the many years that we've been in business and over the many conversations we've had with the license board, we came up with a supervision plan that summarizes the practices that are needed to maintain a valid claim of supervision. Therefore, things like a monthly meeting with your RMO, weekly phone calls, occasional visit to job sites. Generally speaking, your RMO should know about your business, should know what you're doing, should be familiar with your practices, with your trade, and with the type of clients, type of jobs you do, and how you do your work. That will help keep you out of trouble, will help also maintain that your RMO is supervising your operations, and your license should remain valid if there's any dispute with a client or a complaint and so forth. So your RMO is your best ally. Keep him informed, keep him close, and also is a good source, a good resource for advice, second opinion. Most of the RMOs are extremely knowledgeable, extremely experienced, and can be a great source of help to expand your business and to deal with challenges as they come. Dealing with complaints is usually difficult, but the one golden rule is the sooner you deal with it, the faster you resolve it, the better it will be, the cheaper it will be, and you'll be able to get back to business and get back to sales and construction and deal with your expanding your business. And the opposite is also true. The longer you procrastinate, the longer it takes to resolve an issue, the more difficult it becomes, the more costly it becomes, and it can get out of control. Once the complaint gets issued to the license board, there'll be an investigation, there'll be some kind of mediation, there'll be a big risk to your license, can be suspended or revoked. So when you have a problem with a customer, try to deal with it as soon as possible. If you can't resolve it right away, ask your RMO for help. He's more experienced. He may not be so emotionally involved with the project, so it'll be easier for him to help you out. In any case, make sure you involve your RMO, because any complaint doesn't get resolved, he'll be the first to hear about it from the license board. So it is always better that he or she hears about it directly from you and has a knowledge of the problem and tries an attempt at least to resolve it before it gets escalated to the license board. Therefore, the sooner you resolve, the better. Sometimes it's a pain, sometimes it's difficult. Get over with it and get on with your work. Even if your subcontractor has an exemption from workers' compensation, but he brings his employees who are obviously not covered because he is exempt, he or she are exempt, that means that you as a general contractor are responsible for covering them with workers' compensation. So if you work with subcontractors who are exempt from workers' compensation, make sure they don't bring anyone else on the job. And if they do, ask them for workers' comp policy. If you work with licensed contractors who has workers' compensation, then they are responsible for their own employees, and it is not your responsibility.